Hello friends, this video is on Hindu Marriage Act 1955 Part 1, which will include evolution of Hindu marriage and its validity under Hindu Marriage Act 1955. Before beginning to the topic, we need to be well aware about few terms which are mentioned in section 3 of Hindu Marriage Act 1955. Like Section 3, Clause A defines custom and usages according to which any rule which have been continuously and uniformly observed for a long time has obtained the force of law among Hindus in any local area, tribe, community or group or family is defined as custom and usages, provided that the rule is certain and not unreasonable and are not opposed to public policies. Also, it is provided that in case of a rule applicable only to a family, it has not been discontinued by that family. Such practices will be considered as a custom and usages. Coming to the second definition given under clause C of section 3, that is full blood and half blood. Two persons are said to be related to full blood when they are descendant from a common ancestor by the same wife, and half blood when they are descendant from a common ancestor but by different wife. So when two persons are related by full blood, that is they are the children of same father and same mother. But in half blood they can have the same father but different mothers. Coming to the definition of uterine blood that is given in section 3 clause D, two persons are said to be related to each other by uterine blood when they are descendant from a common ancestor but by different husbands. Also, coming to the next definition, that is Sapenda relationship given in section 3 clause F, that is Sapenda relationship under subclause 1, it is with reference to any person extends as far as the third generation in the line of ascent through the mother and the fifth in the line of ascent through the father, the line being traced upwards in each case from the person concerned, who is to be counted as the first generation. So according to Sapenda relationship, two persons are related to each other as a Sapenda when they are traced from the line of ascent. If in the line of ascent of mother, then they have to be traced to the 3 degree, and if they are tracing the line of ascent through the father, then it has to be traced upward to the 5th degree. And two persons are said to be Sapenda of each other if one is linear ascendant of the other within the limits of Sapenda relationship, and if they have a common lineal ascendant who is within the limits of Sapenda relationship with reference of each of them, then they are considered to be in a Sapenda relationship. So to be more clear, Sapenda, we will discuss practically through an illustration what Sapenda is. So if you doesn't get it right now, it's okay, but still Sapenda relationship is traced upwards from the person whose Sapenda we are tracing to the line of ascent. If we are tracing the mother's side, then it will go to 3 generations, and from the father side it will go to the 5 generations. And clause G tells about degree of prohibited relationship, that is two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, or if one has the wife or husband of a lineal ascendant or descendant of the other, if one was the wife of the brother or of the father's or mother's brother or of grandfather's or grandmother's brother, if two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers and two sisters. So these are the prohibited degrees of relationship. Now what reference and why we are studying this prohibited relationship, we will do it further and you will get it as well. So these are the definitions of Sapenda, prohibited relationship, uterine, full and half blood, and custom and usages. Moving on to the next slide, there is an evaluation in the concept of marriage. Like marriage is an essential sanskara of every Hindu and is a sacrament in the Hindu families. Now there are 3 essentials of a sacramental marriage according to Hindus, that is the marriage is a permanent and indissoluble union. So what do we mean by permanent and indissoluble union is that previously marriages were a permanent and indissoluble union and the concept of divorce was not recognized. Also, it is an eternal union. That is, it is traced to the eternity. If one person has marriage, then it is traced to the eternity and they are together till eternity. Coming to the holy union, that means it is essential to perform religious ceremonies, which make them a holy union and uh, create as a blessing of a god. So initially polygamy was recognized, but Hindu Marriage Act 1955 abolished it and established monogamy as a strict rule along with the introduction of divorce. So the evolution of concept of Hindu marriage came after Hindu Marriage Act when polygamy was abolished and monogamy was established. Also the concept of divorce was introduced, as earlier divorce was not recognized in Hindus. Now, question arises that in modern times is Hindu marriage a contract or a sacrament? Like we are well aware about Muslim marriages, they are a contract. Now, what about Hindu marriages? So, recognition of divorce and widow remarriage was diluted the elements of sacramental marriage. So, when we recognized divorce and widow remarriage in the concepts of Hindus, then it is said that it has dissolved the sacramental element of the marriage. Also, the necessity of sacred or religious ceremony to perform valid marriage under Hindu Marriage Act is as well given. So, on one side, it has introduced divorce and widow remarriage. On other side, it also essentialize or make it compulsory for religious ceremonies to take place for Hindu marriage to be a valid marriage. Also, the Kanyadan ceremony, that is a gift of a daughter in marriage, signifies to be a contract. So, Hindu marriage has a semblance of both contract as well as sacrament. Now, what forms and ceremonies of Hindu marriages are compulsory? Okay, so under customary Hindu law, certain shastric ceremonies were recognized, like Saptapadi, Kanyadan, Panigrahana, Vivahoma. Like Saptapadi, we all are well aware of Satfere. Kanyadan is also very known term. But Panigrana is a ceremony like a ritual in presence of fire, where the groom take the bride's hand as a sign of their union. And Vivahoma is another ceremony which is essential ceremony in Hindus. That is, after the Kanyadan takes place, the sacred fire is lit and the couple praises in the Agni Devta, the lord of fire, in hope of bringing the presence of Vishnu onto the ceremony. Vivahoma is performed in order to indicate the purity of our upcoming rituals, all conducted with the help of fire. So, Hindu Marriage Act 1955 does not provide for any specific form of ritual or ceremony for marriage, but as under Section 7 provides that it would be a valid marriage if it is performed by necessary customary rites and ceremonies. So the modern Hindu law is not clear on which particular rites and ceremonies are essential for a valid marriage. So according to section 7 of Hindu marriage, should be performed by customary rites and ceremonies which first must prevail on either side and second followed continuously from ancient times and regarded to be obligatory by members of caste and community. So the rituals and rites may vary from tribes, communities or person to person, but it must be a ceremony which is socially accepted by that community of the bride and groom. So there is no specific ritual, but ceremonies can be varied, but there must be some religious ceremony done for the marriage to be a valid marriage. Coming to our forms of Hindu marriage, according to Puranas, Hindu marriages, there are 8 of marriages. Coming to Brahma marriage, Brahma marriage is a kind of marriage where there is a gift of a daughter, clothed and decked to a man learned in the Vedas, whom a father voluntarily invites and respectfully receives, is the nuptial rite. And that type of marriage is called as a Brahma marriage, where the father gives his daughter to the person who is well known in Vedas. Then comes as Deva marriage. The rites which sages call Deva is a gift of a daughter whom a father has decked in attire when the sacrifices already begin, and to the officiating priest who performs the act of religion. So according to Manu, as the gift of daughter, after having adorned her to a sacrificial present, rightly doing his work in a sacrifice began. To be more clear, Deva marriage, in simple words, is the marriage where the father gives his daughter to a man who is doing their religious ceremonies or sacrificial works. That can be of any priest, and hence giving a daughter to the priest is called as a Deva marriage. Brahma marriage and Deva marriage are sorts of particular, but Brahma marriage, the groom has to be well aware of Vedas, while in Deva marriage it has to be a priest. Coming to the Asura marriage, the bride was given to the husband in payment of a consideration called sulka or bride price. When the bridegroom have given its much wealth as he can afford to the father or paternal kinsman, or to the damsel herself, takes her voluntary as her bride. It is called as Asura marriage. So, Asura marriage in simple words is when the groom can afford and give all his wealth to the bride's father or kinsman, and takes the bride as a consideration for that. Like in Ramayana it is mentioned that a fabulous amount of bride price was given to the guardian of Kekai for her marriage with King Dashrath. Coming to the next, that is Gandharva marriage. The Gandharva form of marriage is a union of a man and a woman by mutual consent. According to Mani, the voluntary connection of a maiden and a man is to be known as a Gandharva union, which arises from lust, or is also called as it is also called as a runaway marriage. Even the Swayamvars, where the marriages, as found in the epics and the Puranas, may be conceived as a Gandharva form of marriage. Then comes fifth, that is Prajapatya marriage. In Prajapatya marriage, the father gives away his daughter with the due honor, saying distinctly, "May both of you perform together your civil and religious duties. You to be the partners for performing religious and secular duties." So, the very name Prajapatya indicates that the pair enters the solemn bonds for repayment of debts to Prajapati for procreation and upbringing of children. So Prajapatya marriage, the father gives his daughter to the man, offering them to go and do their religious and secular duties. Then comes Arsha marriage, where the father gives his daughter away after having received from the bridegroom one pair of cattle or cows, or two pairs for uses prescribed by law. That marriage is termed as Arsha, as simple as that. Then comes Rakshasa marriage. Now, Rakshasa and Pashaja marriage are the low types of marriages, lowest forms of marriages. Like Rakshasa forms of marriage are the marriages by capture, resembling the right of a victor to the person of a captive in war. Manu holds it that as a seizure of a maiden by force from her house, while she weeps and calls for assistance after her kinsmen and friends have been slain in battle or wounded, and their houses broken up open, is the marriage styled Rakshasa. So when it is a non-consensual marriage where woman is weeping for help and the kinmen and the father or family members are wounded in the battle by the groom, and then he marry her, is called as a Rakshasa marriage. Then comes Pasacha marriage, when in simple language we can describe it as when a man by stealth seduce a girl who is sleeping, intoxicated or mentally challenged, is called as a Pasacha marriage. So these are 8 kinds of marriages. Those students who might have been pursuing BA LLB must have read these kinds of marriage in their sociology. Now, coming to the validity of Hindu marriage, under Section 5 of Hindu Marriage Act, there are few essential conditions of valid Hindu marriage. That is, a Hindu marriage may be solemnized between any two Hindus if the following conditions are fulfilled. That is, neither party has a spouse living at the time of the marriage. That is, the marriage must be a monogamous marriage and should not be a bigamous or polygamy. Hence, neither party has a spouse living at the time of marriage. Then, at the time of marriage, neither party, first, is incapable of giving a valid consent, or it is in consequence of unsoundness of mind, or though capable of giving a valid consent, has been suffering from some mental disorder of such a kind, or to such an extent as to unfit for marriage and the procreation of children, and also has been subject to some recurrent attacks of insanity of epilepsy. Now, mental capacity to marry is given under section 5 clause 2, that is, any person is said to be not in a mental capacity to marry, that is a person who might be suffering unsoundness, or who might be able to give his consent, valid consent, but may not be mentally fit to be fit for marriage or procreation of children, and or might be having some attacks of insanity of epilepsy. These three kinds of people will come under mental capacity to marry. Then comes clause 3, that is, the bridegroom has completed the age of 21 years and the bride or the age of 18 years at the time of marriage. So the age of bride and groom must be completed, that is, for boy to be 21 years and girl to be 18 years of age to come under a valid marriage. Then coming clause 4, the parties are not within the degree of prohibited relationship unless the custom or usages governing each of them permits of a marriage between the two. And fifth, the person are not subpendas of each other unless the custom or usage governing each of them permits of a marriage between the two. So as we done, first monogamy, second age of bride and groom, third mental capacity to marry. The both clause 4 and 5 of section 5 tells about relationship by blood or affinity, that is restriction by prohibited relationship or subpenda relationships. We will do it in more details to get a more clarification. Coming on the first, that is monogamy, section 5 clause 1 and section 11 and section 17 specifically talks about this concept. Now, section 5 clause 1, as we have already read, that neither party has a spouse living at the time of the marriage, that is, it restricts bigamous form of marriage. And section 11, that is void marriages, says that if a person is doing bigamous marriage, that is, if it is he is doing a second marriage with subsistence to the first marriage, then that marriage will be void under section 11. Okay, so section 11 make bigamous marriages void. And coming to section 17, bigamous marriage is punishable offenses for both Hindu males and females. So section 17 come out to punish those marriages which are bigamous in nature. Now, bigamous marriages to be penalized must fulfill two conditions. That is, first, it should have a perfectly valid first marriage. So that by mean perfectly valid first marriage, there should not be voidable or invalid. The first marriage should be perfectly valid and must be subsistent at that time. And second essential is the second marriage performed by proper shastric customary and ceremonies. So for bigamous marriage to be penalized, the first marriage to be perfectly fine, perfectly valid, and the second marriage which is performed must also be perfectly performed by customary ceremonies. Now, if these two conditions are fulfilled, then person is liable for bigamy. In when it comes to burden of proof, the prosecution to establish performance of second marriage during subsistence of valid first marriage. So the prosecution has the burden of proof to prove that the first marriage was valid and the second marriage is also performed through customary ceremonies. Coming to the cases, there are three essential cases according to me for this. That is, first is Priya Bella versus Suresh Chandra case. It is a 1971 case decided by Supreme Court. It was a case when husband and wife were having a good relationship, but after some time husband started harassing and beating the wife, so wife went to her home, father's house. After some time husband came to her and told that he has committed bigamy with her, that is, he has done a second marriage. So wife sued him to the court for it, and after whole prosecution and case went through proceedings trials, then Supreme Court held that the mere admission of crime cannot be treated as an evidence, as there was failure of evidence to prove that the second marriage was done successfully by performing those rituals and ceremonies. Even the man failed to prove that second marriage was successfully and perfectly validly done. So, in case court held that there is no evidence that second marriage is actually successfully done, and hence bigamy is not there, and his first marriage is subsisting. Second comes the Sarla Mutkul versus Union of India case. It is a landmark judgment for this. It was a case of 1995. So it was the case when facts of the case are as Hindu male converted himself to a Muslim and then married a second wife. And when he was questioned that he was not allowed to do so, he excused it as that now he is a Muslim and he is allowed to do bigamy. So even when his first marriage was subsistent, court held that second marriage was void, as when he married the second woman, his first marriage, which was done according to Hindu law and Hindu ceremonies, it was still subsistent, and hence he is liable under bigamy. Then came Lily Thomas versus Union of India case of 2000. So it was the same fact as of Salamudgal, and Salamudgal case was again challenged here. Then court held that no Salamudgal versus Union of India judgments will be upheld. Hence, no one can do bigamous marriage by converting them to Muslim, because if Supreme Court allowed it, it will create a loophole, and every second one will get a excuse to do bigamy. And hence, court held that previous decisions will be upheld, and one cannot do convert himself into Muslim and do a second marriage when his first Hindu marriage was subsistent. Then coming to the second, that is mental capacity to marry. It is given in section 5 clause 2 that stipulates mental capacity for a valid marriage. The person at the time of marriage should not be of first unsound mind or mental disorder, or must not be suffering from recurrent attacks of insanity of epilepsy. If any one of these three are existing, then the person is not capable to marry, and hence that marriage can be declared void. Now, in the case of Alka versus Abhinesh, that was a 1991 case, facts of the case are as the husband pleaded in the petition and sought to be proved by evidence and support. There was that soon after the marriage, that is on honeymoon night itself, he discovered that the wife was abnormal and erratic in behavior. She refused sexual intercourse on the very first night and showed all signs of a person not mentally sound. It was also stated that during her second visit, on one occasion, she became extremely uncontrollable and violent, so much so that the psychiatrist had to be called and examine her, who confirmed that the wife was a mental case of schizophrenia and she had been under treatment since before her marriage, which wife totally refused. But it was proved that wife was of unsound mind and was suffering from schizophrenia, and hence she was held mentally not fit for marriage and unsound. So this is a concept how the person unsound, mental disorder, or suffering from insanity or epilepsy are not capable for marriage, and those marriages are not valid. Then coming to the third, that is age of bride and groom, which is given in section 5 clause 3. Now, according to section 5 clause 3, for bride and groom to have a valid marriage, the age of bride must be 18 years of age, and groom should have completed 21 years of age to perform a valid marriage. According to section 18, contravention to section 5 clause 3 punishable, such marriage is neither void or voidable but only punishable. So like a concept of child marriages. So uh, basically, reason behind it is that for children's married once, and then for a girl especially, once if she is married and then get divorced or any reason, get that marriage declared valid void. So now it is the society where it will become hard for that woman to get married again or be seen in a society as a normal human. So, according to Section 18, that marriage which is done for a woman below 18 years of age or groom below 21 years of age won't be void or voidable, but people who make them married will be punishable under Section 18. Now, in the case of P. Venkatramana versus State of Andhra Pradesh, that is a case of 1977 Andhra Pradesh, validity of marriage between minor age 13 and 9 years was in question. So court held that such marriage was perfectly valid as the law only provides punishment for such marriages. Now, coming to the next, that is relationship by blood and affinity. We will first come to section 5 clause 4, read with section 3 clause G. Parties to marriage should not be within prohibited degrees of relationship unless custom and usages governing them both permits otherwise. So according to section 5 clause 4, we have read that prohibited degrees of relationship, one cannot marry within their prohibited degree of relationship unless the custom and usages of those parties govern them and permit them to do so. If it is not allowed in their customs and usages, then they are not allowed to do a marriage under prohibited degree of relationship. Now, what prohibited degrees are is given under section 3 clause G, which we have already read. Then coming to the section 5 clause 4, 5 clause 5 read with section 3 clause F, which is Sapenda relationship, which we have discussed just above. We will do it in detail now. So parties to marriage should not be Sapendas to each other again unless custom or usages governing both permit otherwise. So unless the customs and usages of the parties allow them to do so, they can do it. But if it doesn't allow it, then they are not allowed to marry within their sapendas. Now, what actually sapenda relationships are? So Vijnaneshwara defined as sapenda relationship as pinda, that means body. So sapenda means persons who are particles of the same body. Marriage between sapendas is the highest sin according to Vijnaneshwara. Hindu Marriage Act 1955, 5 degrees in line of ascent through father and 3 degrees in line of ascent through mother are the sapendas, and those people related to sapendas are not allowed to marry. Sapenda relationship is always traced upwards. Degrees are computed inclusive of person consent concerned and common ancestor. So what we mean by degrees are computed inclusive of person concerned and the common ancestor, like the figure I have mentioned in this slide. Let's first understand it. F is the father, and at the below FDSSD is the bride, and FSDS is the groom. F is the father who gave birth to FS and FD. FS gave birth to FSD, that is daughter, and FSDS is the son of FSD. Here F means father and S means son. So FS is father's son, FSD is father's son's daughter, FSDS is father's son's daughter's son. Again, coming to the next side, FD is father's daughter, FDS is father's daughter's son, FDSS is father's daughter's son's son, and FDSSD is father's daughter's son's daughter. Now, FSDS, that is groom, and that is bride, both are wanting to marry. Now, there's a question that they both are in Sapinda relationship. So when we said that degrees are computed inclusive of person concerned and the common ancestor, that means that the person concerned must be counted as one, up tracing upwards to its common ancestor. till they get the common ancestor. So, Sapenda relationships may subsist only through the father or only through the mother for both the parties, or it may be through the father in case of one of the parties and through the mother in case of the other. Like Section 5, Clause 4, two persons in prohibited degree of relationship cannot marry each other. So, before discussing Sapenda, we already did prohibited degree relationships, and in prohibited degree of relationships means that one in a lineal ascendant go to the other. There is no limit of degrees. Neither one can marry wife or husband of the lineal ascendant or descendant of the other. One cannot marry the brother, father's brothers, mother brothers, grandfather's brother, grandmother's brother. Brother and sister, uncle, niece, aunt, nephew, children of two siblings. These all are the relations which come under prohibited degree. Then when we comes to the Sapenda relationship, according to, we will discuss all Sapenda through this diagram. Now counting, as we said that the Sapenda must be traced upward from mother's degree to 3 generations and from from father's side to 5 generations. So coming to the groom, FSDS. So now we are tracing FS to FSD, that is mother's side. So groom's mother sides and bride's father sides are having a common ascendant to each other. Now coming to groom, we count groom as 1, FSDS as 1, FSD as 2, FS as 3, and common ascendant that comes as 4. So now from groom side we are tracing upwards to mother side, that is FSD. So when we are tracing to mother side, we go to 3 generations. Now common ascendant is to the 4th generation. Hence, groom is not the Sapenda for the bride. But let us come to the bride side. Now FD double SD is tracing its ascendant line of ascent from its father's side, that is FDSS. So when we count bride as 1, FDSS as 2, FDS as 3, FD as 4, and F as 5. When we trace a line ascendant to the father's side, we trace it to the 5th generation, and common ascendant is in the 5th generation. Hence, bride is the Sapenda of the groom. Hence, they can't marry each other, as the bride and groom are Sapenda to each other. May not be from groom side but are from bride side. Hence, they can't marry each other. So this is what the Sapenda relationships, and if they marry each other, then such marriage is void. So here we have done about validity and how evolution of Hindu marriage has come out through this modern times. On my next video we will discuss about voidable marriage, and then grounds for divorce, and also about the that is restitution of conjugal rights and matrimonial remedies that are given in Hindu Marriage Act 1955. Thank you.